Namaste and welcome to this edition of The Right Stand. Ladies and gentlemen, should the law not be equal for everyone? Obviously, the answer is yes. So, if an act of parliament can be challenged in the court of law with the grounds that this act is not favorable to the people at large, so then that's a good position, that's a right position. But then, can an act of parliament be rejected by the court or turned around and said that this does not apply in a particular case and therefore a case be created? And should people turn around and say, oh, this act has been passed by parliament, so the court cannot take a position about it or around it? Now, is that not a double standard? In the Gyanvapi matter, there are multiple aspects to this entire Gyanvapi aspect of Kashi Vishwanath, ladies and gentlemen. Let's understand this very clearly. What's happened today is with respect to Ma ShringarGauri. The deity of Ma ShringarGauri is in the northeast corner of this Gyanvapi Parisar, and that too behind on a wall. That's where Ma ShringarGauri is. And not just 15th of August 1947, but till 1993, deity was worshipped by the devotee on a day-to-day basis. There was continuous worship of the deity. Let me ask you another question. Think about it. Is worship different than prayer? You can pray anywhere and everywhere. But can you worship anywhere and everywhere? Are these two different concepts? Again, a matter that needs to be thought about. This fight, why is it a fight is another question. Why should there be a fight where one Paksh can say, I have the right to pray here, but will stand in court and say that the other Paksh does not have the right to worship here despite them worshipping way beyond that date of 15th August 1947. So my right to pray should be upheld, but another group's right to worship and right to pray will be limited or restricted. Is that equanimity? Is that samabhav? Is that Ganga Jamuni? These are questions. But who is going to decide this? It is the court of law. Will they allow the court of law to decide? And when the court decides, will they turn around and then question the very courts itself and call them compromised? So, heads I win, tails you lose. Is that Ganga Jamuni? These are questions that remain, ladies and gentlemen. But what's happened today is Prathama Padam, the first step. That's what Hindus believe, towards Vijaya Sunishchayam. That means determining victory, the first step towards the big victory. That's what the Hindu Paksh believes.
प्रतिपक्ष का जो है 7-11 इस पर लागू नहीं होता, वक्फ बोर्ड लागू नहीं होता और इसमें हिंदू समाज की तरफ जीत हुई है।
आज दिए जलाए, शंख नगाड़े बजाए, हर हर महादेव का नारा लगाए रात के 8 बजे। आज बहुत बड़ी दिवाली है, आज शिव की नगरी में बहुत बड़ी दिवाली है।
इस फैसले का मैं भी स्वागत करता हूँ, सब लोग स्वागत करें और किसी भी प्रकार से इस विषय को लेकर के कोई विवाद उत्पन्न करने का काम ना करें।
आज के ऑर्डर के बाद ऐसा लगता है कि फिर अब ये लिटिगेशन शुरू हो जाएगा इन तमाम इश्यूज के ऊपर और हम दोबारा 80 और 90 के दहे में वापस जा रहे हैं। फिर फौरन इसके खिलाफ हाईकोर्ट में अपील होनी चाहिए।
So that's the straightforward question. Can the Hindu Paksh prove the case? So we'll test the Hindu Paksh this evening, ladies and gentlemen. You will look at the panel, you will say, oh, where is the Vipaksh? Fact is, we are just going to ask the Hindu Paksh, it's your day of victory. The next step is that you have to prove your case. So do you have enough merit to prove the case? So we'll have a lot of people who have filed a lot of cases as far as this entire aspect of right to worship and right to pray for the Hindu Paksh at various levels. And we will test them, including the lawyer in this case, Harishankar Jain's son, Vishnu Shankar Jain, who's one of the chief petitioners. He's also moved court on some of the other matters with Adi Vishweshwar and the Shivling. But this is Ma Shringargauri. That's what we will talk about and limit ourselves tonight. The 10 big takeaways from the court order. 26 pages of the court order, where 3 acts or 3 laws have been tested and then rejected. The Waqf Board Act, the Kashi Vishwanath Act of 1983 and the Places of Worship Act of 1991. Of course, the Deen Mohammed case has also been quoted and there has been an observation on that matter also. We will bring that up also. This is dated 1936, where there was no representation of the Hindu Paksh. But what are the 10 takeaways? Suit is not barred by any provision of Places of Worship Act. First one. The next point, very clearly, the foundation has been laid to establish Hindu character of the property by the Hindu Paksh. That's also mentioned in the judgment. But they have to go ahead and substantiate it. Then, deities mentioned existed within property before the 15th of August 1947. Thereafter, they say the Ayodhya case establishes the right to initiate suit to protect the deity. The Ayodhya case is also mentioned to decide what should define or what defines the religious character of a place. And that is a particular structure important for prayer and is a particular structure important for worship. Even in the absence of the deity, does the religious character remain? All of that has been mentioned in this judgment. We'll talk about it. Ayodhya case also establishes a legal personality to idols. The destruction does not result in termination of the pious purpose. This is quoting the Ram Janmabhoomi verdict of the Honorable Supreme Court in this judgment too. Devotees were allowed to freely worship Ma Shringargauri till 1993. So whose right to pray has been restricted, right to worship has been restricted? Government of Uttar Pradesh in 1993, that's the claim being made, restricted the entry of devotees without a written order. It was just orally communicated. It was never challenged, this order. Plaintiffs are only demanding the right to worship Ma Shringargauri. They are not claiming title to that wall, nor saying call this a temple. They are saying this place we have come to worship, allow us to access. Don't bar our access. No suit has been filed for declaration of disputed property as a temple. And the right to worship is a civil right. And any interference will raise a civil dispute. That has also been established by the court, saying the court is well within the rights to not just decide on the maintainability but also hear the petition. Now, what are the legal ramifications? The big 5. First, the Astha fight opens up. The right to pray gets a big boost. Right to worship gets a big boost. It paves the way to bypass 1991 Right to Worship Act or to understand, interpret legally the tenets of Right to Worship 1991 Act. And where does it work? Of course, the Right to Worship Act itself is unchallenged. And the petitioner is joining us in a short while. Move towards ASI survey, Archaeological Survey of India, plus further survey of the mosque. So the Advocate Commissioner survey now comes into play. Those 9 to 12 pages, which had a lot of observations, those videotapes, they all come into play. Of course, it also opens the Pandora's box to similar disputes where people will turn around and say, I don't want title, just give me access. Court cognizance possible now of report on the Shivling too. Oh, that aspect comes through. But we will focus on Shringargauri and its various dynamics. So the plea upheld. Can the Hindu Paksh prove the case is what we are asking. The GyanvapiShringarGauri, that's the hashtag. Let's go across to our guests this evening. Vishnu Jain, Advocate Supreme Court and one of the petitioners in this matter. And of course the involved party. Rajat Sethi, political analyst. Dushyant Sridhar, Vedic speaker and writer. So we will go back to the historical concept. What do you understand? And this concept of Prana Pratishtha, perennial rights of the deity, where does it come? And of course, I have Ashwini Upadhyay, petitioner, joining us in the studio. Namaste. So he's got a angle between, like I asked you this question, prayer and worship, are they two different aspects? But first, let's go to Vishnu Jain. Vishnu ji, namaste.
हर हर महादेव।
देखिए, मेरे से पहले अश्विनी जी कह रहे हैं हर हर महादेव। आपके साथ जो याचिका करता है वो भी है, वो भी आपके साथ है। नमस्ते, हर हर महादेव।
हर हर महादेव कह रहे हैं।
हर हर महादेव।
So Vishnu, let me ask you, how do you see the judgment today? What does this imply?
See, the important point is, Anand ji, that so far as we were arguing on your channels and on your studios time and again, that in this particular set of facts, the Places of Worship Act is not attracted, because before 15th August 1947 there was a pre-existing Hindu temple, and till November 1993 every day we used to worship Ma Shringargauri. It is only after November 1993 this worship has been stopped, and therefore we had filed this petition before the Honorable District Judge of Varanasi seeking daily worship of the property in question. And today the Honorable Court has cleared the way for trial of the matter in issue. In future course of action, we will be going to lead evidence. The evidence will be pertaining to the historical aspects of the matter. The evidence will be pertaining to the religious aspects and the spiritual books of the matter, which has evidentiary value within section 57 of the Indian Evidence Act. So I feel that there is a lot more work which has to be done. As far as the maintainability issue is concerned, definitely we have won. But so far as the oral and documentary evidence is concerned, we are going to do our preparations for that, and very professionally we are going to proceed further. And I also must tell you that this argument of Waqf Act 1995 has also been rejected by the Honorable Court, because the Muslim side was not able to file any document to show that this is a Waqf property, and the document which was filed as Waqf number 100 was pertaining to Alamgir Masjid, not to Gyanvapi Masjid. And all my arguments which I made before the Honorable Court has been accepted. So I feel that this is the latest example and a grand example that how after legal research and after detailed research in a given set of facts of the case, the Places of Worship Act can be countered and it can be overcome. Definitely Places of Worship Act is a hurdle and will be a hurdle, but we have challenged the constitutional validity of Places of Worship Act.
Correct.
Ashwani ji has also challenged, Subramaniam Swami ji has also challenged. That's a separate issue. That's the dream situation when we get the Places of Worship Act.
We will talk about that also.
But despite Places of Worship Act,
जी, we will talk about.
but despite Places of Worship Act being there,
जी आप बोलिए हाँ complete.
sorry, I am just saying that despite Places of Worship Act being there, through our legal interpretation we have proved that in a given set of facts, the misnomer which has been created in the society, that Places of Worship Act gives a blanket ban that you cannot get your temples restored. It is not that simple an interpretation, and on pure legal interpretation, today's order has been passed.
जी, I want to ask you, Vishnu ji, the ladies behind you who are part of the petitioners, the 5 petitioners, मैं उनसे एक प्रश्न पूछना चाहूंगा कि अप्रैल 2021 में आप में से किसी ने जाकर वहां पूजा की थी? जब लास्ट ईयर उस आपको मेरी आवाज आ रही है?
जी, नवरात्रि के चौथे दिन वहाँ पे श्रृंगार गौरी
Yes, they have worshipped Anand ji.
वहीं पे हम लोग गए थे दर्शन करने।
2021 before COVID.
हम लोग अप्रैल में गए थे दर्शन करने, बहुत सारे लोग गए थे दर्शन करने के लिए।
आप अप्रैल में गई थी ना?
चौखट का दर्शन होता है, बिकरा का नहीं होता है। हाँ, अप्रैल में हम लोग गए थे दर्शन करने। हम लोग चारों लोग गए थे दर्शन करने।
तो एक बात बताइए, अगर आप साल में एक दिन आपको अगर अलाउ किया जा सकता है तो 365 दिन क्यों नहीं? आपके घर में अगर आप पूजा के लिए कहीं रखते हैं पूजा का रूम, तो ऐसा कोई नियम होता है क्या कि साल में एक ही बार वहां पर दर्शन होगा?
इसी की तो लड़ाई हम लोग लड़ रहे हैं, इसी की लड़ाई लड़ रहे हैं ना कि चौखट का पूजा नहीं, हम लोग को बिगड़ा का पूजा, हम लोग को 300 साल में 365 दिन हमको मतलब पूजा हम लोग को दर्शन करने के लिए दिया जाए, न कि साल में एक दिन। इसी की तो लड़ाई हम लोग लड़ रहे हैं, श्रृंगार गौरी का।
पर आर्ग्यूमेंट विष्णु जी, द आर्ग्यूमेंट नाउ विल बी, हाँ जी बोलिए, आप बोलिए, फिर मैं विष्णु जी से पूछता हूँ।
नहीं पूछिए भैया से पूछिए आप।
ठीक है, तो भैया विष्णु भैया मैं आपसे पूछ रहा हूँ, आई एम गोइंग टू आस्क यू दिस, द आर्ग्यूमेंट इज दैट यू आर गोइंग टू फर्स्ट से कि अलाउ अस टू वर्शिप, अलाउ अस टू प्रे, then you will say, "Arey, we are only the larger number," and then you will try and take that place and saying this place belongs to us. So you will try and this is a backdoor entry. This was one of the arguments that was made.
No, Anandji, I'll explain it. I hope I'll be able to explain it. The point is this, that we have filed 6 cases in Varanasi Civil Court. This is one of those cases where only right to worship has been asked. So far as the title of the property is concerned, there is already a title suit pending before the court. So it is, everything will be clubbed together in future courts of action, and then the title and right to worship, everything will go together. So the point in issue is this, that this suit has been filed that till November 1993 in the so-called mosque, there are objects of worship which are existing, and whatever we have claimed has been proved in the commission report where Shivlingam has been found, and therefore we are going in that direction, that whatever is the situation of Gyanvapi as existing in November 1993 after coming into force of the Places of Worship Act in 1991 must be restored. That's one limb of the submission in the petition filed by these ladies. But the point in issue is that there are larger questions.
Please complete, then I'll ask. थोड़ा delay है इसीलिए confusion.
I am saying the point in issue is that there are larger questions. And title and everything has been asked for, so which also will be decided and adjudicated.
Yeah, because in this case you have said 4th day of the Chaitra Navratra Samvat 2078, 16th April 2021, that the devotees performed puja of Ma ShringarGauri. But Vishnu ji, and I'll open it up to our other panelists with this, they are saying कि आप एक नई strategy लेकर आए हैं आपकी बार. तैयारी ये है कि हम तुम पर इतने केस कर देंगे, तुम कंफ्यूज हो जाओगे कि डेट कहां पर लें और लड़े कहां पर. एंड दिस इज द रीजन व्हाई आई एम सेइंग दिस. आई एम सेइंग दिस बिकॉज द एडवोकेट कमिश्नर सर्वे रिपोर्ट which was done for one other case will now come into play in this case also. It will also come into play in some of the other cases.
This, Anandji, I understand what you are trying to say, but the point is that the CPC gives me permission. Rule 4A of the CPC gives permission of clubbing of all the matters, and then if a report has come in one given set of facts, that report can be given, that report can be read into the other cases which have been filed for the similar issue. So this is the point. The point is of filing of the cases for restoration of our temple. Lord Shiva, who is the destroyer, can never be destroyed, and therefore he is the creator also, he is the destroyer also. He can never be destroyed, and therefore this is a legal battle for restoration of the temple of Lord Shiva. And let me tell you, Anandji, it is not my words. Honorable Mr. Justice Ramaswamy, in the judgment delivered by the Supreme Court, where the Kashi Vishwanath Act was constitutionally challenged, in that judgment he has said that out of 12 Jyotirlings, 5 Jyotirlings are Swayambhu, and this is the very first of all the 5 Jyotirlings.
Yeah.
So it has our own, this Kashi place, and this particular place has very significant role for the members of the Hindu community, and therefore time and again we are saying that it has to be restored. There is categorical evidence that even after demolition by Aurangzeb, Hindus used to worship in the plinth of the so-called mosque, and no temple has been, and the so-called mosque has been constructed over remains and ruins of a Hindu temple. And Anandji, today I want to say something on your channel. When people say and argue this proposition of law that once a mosque, always a mosque, अगर एक बार कोई वफ की संपत्ति हो जाती है तो हमेशा वफ की संपत्ति रहती है. भाई मेरा भी तो हिंदू लॉ है, उसको कोई कब सुनेगा? आज कोर्ट ने सुना है और समझा है, जो मैं बराबर चिल्लाता चले आ रहा हूं कि अगर एक बार कोई संपत्ति देवता में निहित हो जाती है तो समय के अंत तक देवता की रहती है. ये ऑनरेबल जस्टिस बीके मुखर्जी का हिंदू लॉ है, ये पीवी कार्णी के धर्मशास्त्र में जो भारत रत्न रहे हैं उनका ये लॉ है. तो वो सारे हिंदू लॉज को भी पढ़ना है और इसीलिए उसी के आधार पर धार्मिक स्वरूप तय करना है.
करेक्ट, बट आप तो लॉ तब पढ़ेंगे जैसे आप देखना चाहते हैं विष्णु जी. देयर विल बी अदर्स हु विल सी द लॉ एज दे वांट टू इंटरप्रेट इट. But Dushyant Sridhar, before I bring, if with your permission, I'm just going to bring in some of our other friends this evening, and then I'll come back to you, Vishnuji, and please feel free to jump in whenever you want. It's an open discussion. So, Ashwini ji, before I come to you on the legal aspect, I'm just going to Dushyant Sridhar, is a Vedic scholar. So let me ask you, the counter argument is that once the Isht is there, Pran Pratishtha is done, the deity is there perennially. So whether I worship him once in a year or whether I worship him all 365 days, it's the same matter. Deity is always present. So why do you have to worship all 365 days?
Namaskaram Anand, and namaskaram to my fellow panelists. With respect to the Agama as a science that kind of dictates as to how temples should be constructed, how the deities, the Vigrahams or the Murtis have to be established, the Prana Pratishtha has to be done, and how regular maintenance has to be done. With that little knowledge, I can tell you, be it the Vaishnava Agama or the Shaiva Agama, Aradhanam has to be done trikalam. It has to be done in the morning, in the noon, and in the night. So the understanding in Sanatana Dharma is, Anand, that the deity whom we establish in a certain temple is like our very own child. So we need to take care of the child 3 times in a day. We don't take care of our child once a year. So that is the basic understanding of a prana pratishtha. And in temples that follow Agama, worship is done thrice a day, and it is done 365 days a year. So even during the lockdown period, certain priests of most temples, though the devotees were not allowed, they were asked to do Aradhanam thrice a day. The temple Aradhanam was not shut. The temples were closed for the devotees, not for the Aradhanam, even during the pandemic period. So the first argument that, well, you can worship once a year doesn't hold well, because Sanatana Dharma dictates that you need to worship the idol 3 times a day. So that's one. And second thing, with respect to temples in Sanatana Dharma, though the religion as such believes that God is omnipresent, He is Sarvavyapi and so on, it does believe in the science that until I worship or realize the formless form of God, the idol worship is very, very important, which is the Vigraha Aradhana.
Correct.
So during the process of Vigraha Aradhana, temples are very important. That is why Rama, whose Janmabhumi is in Ayodhya by the banks of river Sarayu, Krishna's Janmabhumi, which is Madhura or Mathura by the banks of river Yamuna, and Kashi, which is a very, very important citadel of learning, especially for the Shaivism sect of Sanatana Dharma, by the banks of river Ganga, is very important. Unlike most of the Western religions that may not largely believe in a Punya Nadi or a Punya Kshetram, in Sanatana Dharma, Kashi is very, very important. So much so that people who couldn't travel till Kashi in the north made many, many pilot temples in the south. So it's called Shiva Kashi, Ten Kashi, and so on. So they started mimicking Kashi. Kashi is such an important place in Hinduism. And in Kashi, right from the times of, see, the destruction of Kashi temple did not happen just during the times of Aurangzeb. Right from the times of Muhammad Ghori, the 12th century, there's a beautiful mausoleum built by a scientist, Pakistani scientist, if I'm right, Abdul Qadir Khan in 1995 for Muhammad Ghori, the one who destroyed the Vimanam of Kashi temple. It has all been recorded in the inscriptions and the manuscripts. Followed by the Lodhi dynasty that destroyed, and then Aurangzeb took complete pride in his decrees to tell that I have ordered the destruction of the temples in Kashi. So all that is very well documented, not by a person of any other religion, but by a follower of Islam itself. So the temple of Kashi has been destroyed, and on the remains in which the temple has been constructed, but there were certain idols that were left. There was another argument, Anand, just for the viewers' sake, that can Hindus worship a broken idol? There is a agamic science that tells that if the idol is broken, you can construct a similar idol and do the prana pratishtha in the same place. So if somebody shows broken forms of Nandi or Gauri or Shiva, that doesn't matter. New idols can be placed, but the place is very important in Sanatana Dharma.
Right, very well said. Even in the judgment here, Ashwini ji, and before I bring in Rajat Sethi here, the Hindu Law of Religious and Charitable Trust, Tagore Law Lectures, B.K. Mukherjee, 5th edition, has been quoted in the judgment, where they say, Eastern Law House, in which at page 150 it has been mentioned that before the image can be used for worship, it has to be properly consecrated. Once consecrated, that is Pran Pratishtha is done, then what happens is the deity is believed to reside within the form of the Vigraha of the image, which is thus a symbolical reflection of the Pratima of the deity and becomes worshipful Archa. The image is now treated as a living being. And even after they say, they say that the power of the god Shiva is believed to be ever hovering over the form of his consecrated linga. That means, like Dushyant Sridhar was saying, ki even if the idol breaks or whatever happens, you can reconsecrate because it is considered to be there all the time. But in this case, let me ask you this. They are not saying pray, they are saying worship. How is worship and pray different? You've challenged the suit on that, and you've also challenged this Places of Worship Act 1991.
Yes. There is a huge difference between place of worship and place of prayer. Place of worship मतलब पूजा स्थल, जहाँ पे पूजा करते हैं. मंदिर को पूजा स्थल कहते हैं. वहां पे पहले प्राण प्रतिष्ठा होती है, पहले भूमि पूजन होता है, विग्रह की पूजा बाद में होती है। पहले उस भूमि की पूजा होती है, उसके बाद वहां विग्रह बैठाया जाता है, शिवलिंग बैठाएंगे या देवी जी की मूर्ति बैठाएंगे, फिर उनकी पूजा होगी। और मंदिर के लिए, पूजा स्थल के लिए इवन मंदिर का होना जरूरी नहीं है, आप पीपल के पेड़ के नीचे वहां पे प्राण प्रतिष्ठा करिए, भूमि पूजन करिए, शिवलिंगम वहां रखिए, वहां पे पूजा शुरू कर दीजिए। कल को आंधी आए, अगर वो पीपल की डाल कोई टूट जाए या पीपल का पेड़ टूट जाए, उससे वहां के जो धार्मिक सैंक्टिटी है, रिलीजियस सैंक्टिटी, वो चेंज नहीं होती है। आप नीम के पेड़ के नीचे, पूरे भारत में बहुत सारे स्थानों पे नीम के पेड़ के नीचे शिवलिंगम रखा जाता है, प्राण प्रतिष्ठा होती है, फिर पूजा शुरू हो जाती है। कल को वहां नीम का पेड़ टूट जाएगा तो मंदिर थोड़ी खत्म हो जाएगा, पवित्रता वही रहेगी। प्रार्थना स्थल टोटली अलग है। मॉस्क इज द प्लेस ऑफ प्रेयर, नॉट प्लेस ऑफ वर्शिप। क्योंकि प्रार्थना स्थल में केवल आदमी वहां बैठता है, वो उस स्थान की पूजा नहीं करता, वहां किसी देवता की नहीं पूजा करता, वो पूजा किसी और की करता है। मॉस्क में जो व्यक्ति बैठता है, वो मॉस्क में वहां किसी की पूजा नहीं करता, वो प्रॉफिट और मुंह उधर करके बैठेगा, पश्चिम की तरफ, जहां मक्का की तरफ करके बैठेगा। तो प्रार्थना स्थल परमानेंट नहीं होता, प्लेस ऑफ प्रेयर परमानेंट नहीं होता। आपके स्टूडियो में कहीं एक कोने पे हम बना दे प्लेस ऑफ प्रेयर, कि भाई ठीक है, यहाँ पे अगर कोई मुस्लिम को मानने वाले हैं तो यहाँ बैठ के पूजा कर सकते हैं। और कल को आपको जरूरत पड़ी, वहां को कैमरा लगाना पड़ेगा, तो आप कह दोगे अब ये प्रेयर, ये प्लेस ऑफ प्रेयर नहीं, प्लेस ऑफ प्रेयर इधर हो गया। कल को आपको वहां स्टोर रूम बनाना पड़ेगा या कोई और कुछ करना पड़ेगा, वो कहोगे प्लेस ऑफ प्रेयर यहाँ हो गया। जैसे एयरपोर्ट के ऊपर प्लेस ऑफ वर्शिप नहीं होता, प्लेस ऑफ प्रेयर होता है, और वहां कोई भी बैठ सकता है, वहां कोई बैठ सकता है। आपके रेलवे स्टेशन पर प्लेस ऑफ वर्शिप नहीं होता, प्लेस ऑफ प्रेयर होता है। तो और वो जब जरूरत पड़ती है वहां प्लेस ऑफ प्रेयर होता है, कल को वहां जरूरत पड़ती है स्टोर रूम बना देते हैं, कल को जरूरत पड़ती है वो जीएम का ऑफिस बना देते हैं, कल को कुछ और जरूरत है वेटिंग रूम बना देते हैं, उसको शिफ्ट कर देते हैं। अगर जगह है तो प्लेस ऑफ प्रेयर रखते हैं, नहीं तो उसको भी शिफ्ट कर देते हैं। इसलिए मैं कह रहा हूं कि वंस ए मॉस्क ऑलवेज ए मॉस्क, ऐसा आज तक कोई प्रिंसिपल नहीं हुआ है। लेकिन वंस ए टेंपल ऑलवेज ए टेंपल, ये हमेशा का है। क्यों? क्योंकि वहां पे जब एक बार उस जमीन की पूजा हो गई और वहां पे मूर्ति की पूजा हो गई, उसके बाद उस स्थान का जो मालिक है ना, उसका जो मालिकाना हक, वो डीटी को चला जाता है। शिव, अगर भगवान शिव है उनको जाएगा, कृष्ण की मूर्ति उनको जाएगा, जो भी होगा उसको मालिक। और एक बार उस जमीन का मालिकाना हक जब भगवान को चला गया, तो इवन किंग, राजा भी उस जमीन को नहीं बेच सकता, उस राजा भी उस जमीन को किसी को नहीं दे सकता। मैं दूसरा एग्जांपल देता हूं। हमारे घर में मंदिर है, एक बार हमने मंदिर की प्राण प्रतिष्ठा कर दिया, पूजा कर दिया। अब मैं मान लीजिए इस्लाम कबूल कर लूं या क्रिश्चियन बन जाऊं, तो मुझे तो क्रिश्चियन बनने का अधिकार है, मुझे इस्लाम कबूल करने का अधिकार है। लेकिन वो जो मंदिर है ना मेरा, उस मंदिर को तोड़ के वहां मस्जिद बनाने का अधिकार नहीं। वो भले ही मेरे घर में हो, मेरे दरवाजे में हो, और मेरी जमीन से हो, मेरे पैसे से बनाया गया हो। दिस इज द प्रिंसिपल।
But that's a principle, but that's not what is followed. That is not what is followed. What is followed right now, and that's what the point is. Like Dushyant Sridhar, there can be a counter argument. If Ma Shringargauri, where she is today, if that is going to create social strife, and there is going to be a perennial conflict, why can't Ma Shringargauri be moved from there and established somewhere else, so the devotee can still access the deity, but there is a process of reconsecrating the deity?
Anand, I just have to intervene if you can.
Yeah, that is, I'm asking you only, Dushyant.
Now so to the question, I'll give you a very similar example in the south of India. For example, when Parvati was cursed by Shiva that she should be born on earth and she should be worshipping him, there is a place where she uses the mud, the earth, to construct a lingam. That is the place called Ekamreshwara temple in Kanchipuram. So now what happens is the lingam becomes important. At the same time, she has chosen that place. See, that place is very, very important for us. So, for example, you tell, let the ShringarGauri move out. Probably, as per the Sthala Puranam of Kashi, Gauri has chosen that place. So, she has chosen that place, so she should be asked again if she is okay to move to that place. In Kali Yugam, it is a belief in Sanatana Dharma that in Archa form, Archa is the form where the God exists in the form of idols. So, in that form, Archaka Paradhinaha, she always listens to the priest, or he or she listens to the priest. So, in this case, the gods have chosen in the previous yugas that this is the place where they are going to station themselves. So, I don't think you or I, even though we might call ourselves devout Hindus, have any right to shift the idol to another place.
We don't have the right. Rajat Sethi. Now, Asaduddin Owaisi
don't
has
have the right.
Asaduddin Owaisi comes out and says that this is going to have a destabilizing effect, the court order.
Well, that's for the law and order agencies of the respective states to take care of. He is not in charge of the law and order of Uttar Pradesh. Yogi Adityanath ji is. So we as citizens of this state, we expect him to ensure that no untoward incident happens. He has no locus standi on that. That's point number one. Point number two is that these two laws, which all the legal luminaries sitting in your studio today clearly said, the Places of Worship Act, and the second is the Waqf Act. These two are the principal troublemakers which have been challenged at various levels. Ashwini ji has challenged the Waqf Act even in the Delhi High Court level. These two acts, the more you read, the more you feel that these two acts cannot exist in a secular polity like that of India. They must go. We are establishing the basic foundations. As you said, there's a difference between places of prayer and the places of worship. These arguments, once concretized in the courts of the law, will form that foundation to completely finish off these two dark chapters of our legal history. And once that is done, it will pave way for ensuring that the titles are also cleared, the rightful, the title to the rightful owner goes, and whatever is done strictly as per law. And whatever the consequences, the state governments and the national government are both empowered to take care of.
No, but
we've seen that the similar sort of fear psychosis was built even with the Ayodhya issue. We've seen how deftly it has been handled. There are prior sort of experiences that the law and order establishment has had. Even today, they ensure that there are strict vigilances across the length and breadth of the state. And you see, there is not a single incident. So this fear-mongering Owaisi should limit himself to his areas where he does that perpetually and not worry too much about Uttar Pradesh.
I just want to play out what Asaduddin Owaisi had to say, and then Ashwini ji, I'll get your reaction on it.
ये जो आज ऑर्डर आया है, इससे देश में अब बहुत सी चीज़ें शुरू हो जाएंगी, क्योंकि 91 का एक्ट इसलिए बनाया गया था ताकि इस तरह के कॉन्फ्लिक्ट जो है वो हमेशा के लिए ख़त्म हो जाए। मगर आज के ऑर्डर के बाद ऐसा लगता है कि फिर अब ये लिटिगेशन शुरू हो जाएगा इन तमाम इश्यूज़ के ऊपर, और हम दोबारा 80 और 90 के दहे में वापस जा रहे हैं। फिर इससे अगर खुदा ना खास्ता अगर हम 80 और 90 के दहे में वापस चले जाएंगे तो ये हर जगह पर एक डिस्टेबलाइजिंग इफेक्ट पैदा हो जाएगा।
साहब पहले अपने आप को ये क्लियर कर दें कि वो बाबर के वंश से हैं या तुगलक के हैं, लोधी के हैं, तैमूर के हैं, किसके हैं मुझे नहीं पता। अगर वो किसी डायनेस्टी के हैं, उसी से आगे बढ़ रहे हैं, उसी की ब्रांच है, फिर तो उनको एक बार बोलना चाहिए, क्योंकि ये लड़ाई हिंदू मुस्लिम की है ही नहीं है। ये लड़ाई भारतीयों की और आक्रांताओं की है। ये लड़ाई सनातन संस्कृति और विदेशी संस्कृति की है। ये लड़ाई स्वतंत्रता और गुलामी की है। हम आज 75वीं वर्षगांठ मना रहे हैं, हम आज़ाद हो चुके हैं। हमारे पूर्वज जिन्होंने जजिया दिया, बहुत सारी परेशानियां झेली, उन मंदिरों को बचाने के लिए बलिदान भी दिया। उन्होंने कभी ये सपना सोचा होगा कि कभी ये देश आज़ाद होगा, कभी ये यहाँ से जितने आक्रांता बर्बर आक्रांता जाएंगे, हमारे आने वाली पीढ़ियां फिर से यहाँ पे अपना उनको आज़ादी मिलेगी, तो उन मंदिरों को मुक्त कराएंगे। सपना सोचा होगा। जैसे आज हम जो काम नहीं कर पाते, हम अपने बच्चे से आशा करते हैं मेरा बेटा ये करेगा, मेरे बेटे का बाद वाला जनरेशन ये करेगा। अब अगर आज़ादी की 75वीं वर्षगांठ मना रहे हैं, आपके पास दो रास्ता है। एक रास्ता है भाईचारा वाला, तो अगर आप भाईचारे के रास्ते से चलना चाहते हो, सबसे अच्छा तरीका है कि जिन स्थानों का जिक्र कुरान और हदीस में है, आप वहां नमाज कंटिन्यू करिए। जिन स्थानों का जिक्र वेद, पुराण, गीता, रामायण, महाभारत में है, रामचरितमानस में, उसको छोड़ दीजिए। भाईचारा भी, सेकुलरिज्म भी मेंटेन होगा। अगर आप ये भाईचारा नहीं चाहते, आप चाहते हैं कोर्ट के जरिए हम लड़ेंगे, फिर आप किसी को दोष मत दो। फिर आप टीवी पे मतलब ये धमकी देने की कोशिश मत करो कि ऐसे हो जाएगा, वैसे हो जाएगा, देश में उबाल। क्यों उबाल आ जाएगा? क्यों उबाल आएगा भाई? हिंदू तो नहीं उबल रहे हैं जिनके मंदिरों पे कब्जा किया हुआ है, और तुमने गोरी गजनी का अवैध कब्जे को लेके बैठे हुए हो, तुम हमको धमकी दे रहे हो। तो मैं इसलिए कह रहा हूं, दो रास्ते हैं। अगर भाईचारा वाला है तो वो तरीका मैंने आपको बताया। अगर आप कॉन्स्टिट्यूशन को मानते हो तो ठीक है, एविडेंस आने दो, गवाहों के बयान होने दो, एएसआई का सर्वे होने दो, कार्बन डेटिंग होने दो, बहुत सारी नई टेक्नोलॉजी आ गई है, सोनोग्राफी होती है, उससे सब पता चल जाए कि अयोध्या, ये काशी का मंदिर कितना पुराना है, काशी की नींव कितनी पुरानी है, मथुरा की नींव कितनी पुरानी है, जौनपुर का अटाला क्या है, भद्रकाली क्या है, भोजशाला क्या है, वो सबका क्लियर हो जाएगा।
पर इसमें आप इतना तो समझिए, विष्णु जैन also should also join us in a bit. Vishnu Jain is with us. Vishnu ji, thank you for coming back. Now, Asaduddin Owaisi says this order will have a destabilizing effect. There will be a slew of other litigations. So Ashwini Upadhyay is saying that Asaduddin Owaisi should clear his point of view. Where does he stand? Does he stand with Bharatiya or Bharat, or with the Akrantas? Our Astha or Akrantas?
See, Ashwini Upadhyay is absolutely right, and what Mr. Owaisi is saying precisely that is what he tried to do in the petition filed by by us and Ashwini Upadhyay ji, because we said that the Places of Worship Act is unconstitutional. And let me tell you, Anand ji, Jamiat Ulama Hind filed an application before the Supreme Court saying that even if notice is issued in this matter, भय का वातावरण पूरे देश में फैल जाएगा। भय का वातावरण आनंद जी हम इस देश में नहीं क्रिएट कर रहे हैं, भय का वातावरण ओवैसी साहब क्रिएट कर रहे हैं, क्योंकि उनको पता है कि उनके पास फैक्ट्स नहीं। और मैं एक बात कहना चाहता हूं, अगर कोई बात लीगल माध्यम से हो रही है, कोर्ट के माध्यम से हो रही है, थ्रू द प्रोसेस ऑफ लॉ हो रही है, then what difficulty he has? He is a barrister, he has all the rights to come and represent the Anjuman Intizamiya and make his point and make his arguments good, because ultimately the decision will not be given by Vishnu Shankar Jain or Hari Shankar Jain or these petitioners. The decision will be given by the Honorable Court, and Honorable Court will give the decision after hearing both the parties. और मैं एक बात और कहना चाहता हूँ आनंद जी, ये कैसा सेक्युलरिज्म है कि आप हमारे मंदिर में आप उसको मस्जिद में कन्वर्ट कर दो, आप मेरे शिवलिंग को वजू खाने में कन्वर्ट कर दो, और अगर आज इस इंडिपेंडेंट इंडिया में मैं उस पर क्वेश्चन रेज करना चाहूं, ये मांग करूं कि उसकी जांच हो जाए, तो आपकी ये आपकी डेमोक्रेसी है, ऐसी डेमोक्रेसी है कि यू आर गोइंग टू से दैट नहीं, इसकी जांच भी होनी नहीं चाहिए। हमने कह दिया कि ये फाउंटेन है तो फाउंटेन है, बस बात खत्म, ये केस यहीं पे क्लोज हो जाना चाहिए। तो इस तरह के आर्गुमेंट्स एक डेमोक्रेटिक सेटअप में कैसे हो सकते हैं? दैट्स द पॉइंट इन इशू। और इसलिए भय का वातावरण हम नहीं क्रिएट कर रहे हैं, ना ये देश 80 के दशक में जा रहा है, ये देश अपने बाबा के रेस्टोरेशन के लिए, स्पिरिचुअल और कल्चरल सक्सेस के लिए आगे बढ़ रहा है।
देखिए, एक बात अगर कहें तो अकबरुद्दीन ओवैसी साहब, दैट इज असदुद्दीन ओवैसी साहब ब्रदर, नॉट सो लॉन्ग अगो वेंट अहेड एंड औरंगजेब की मजार पर उन्होंने चादर चढ़ाई, तो उनका पोजीशन तो कहीं ना कहीं क्लियर होता दिख रहा है। But my point, Vishnu Shankar Jain, is how are you going to turn around and prove? The point, the choice, the challenge is to prove, because they are going to move a higher court. Again, they will take you into maintainability. Even on 22nd, when the whole proceeding starts, you will have to first go ahead and say prove. Right now it is GyanvapiShringarGauri. Before you get to Adi Vishweshwar or the Shivling, you have to first prove GyanvapiShringarGauri.
See, first of all, the Muslim side has to file their written statement before 22nd of September. So I am waiting for the written reply filed by the Anjuman Intizamiya, because till today you have asked us thousands of questions and we have replied to all the questions as to what our case is. But we all don't know that what is the case set up by the Muslim community. When is the date when they came into the possession of the property? Who created this so-called mosque? Whether it is Aurangzeb or it's by Waqf by user, because sometimes some of their lawyers come and argue in the court that it is Waqf by user. Some of the lawyers argue that no, it is created by Aurangzeb. So the court has asked them to file a written statement, which is an affidavit, to our application, to our petition, and then we'll move further. And so far as we are concerned, we have ample evidence, historical records, spiritual records, legal records, which we will file in the matter in issue, which will be exhibited in this case and in future course of action through detailed evidence, documentary as well as oral, will prove to the hilt that in this property in question there was a pre-existing temple, and the character of the property as existing today also, as well as after coming into place of the Places of Worship Act, was of a Hindu temple.
जी, अश्विनी जी wants to say something.
देखिए, ये बार-बार संविधान की दुहाई दे रहे हैं। एक्चुअल में ओवैसी संविधान को हम नहीं मानते, ना ओवैसी की जो समर्थक वो मानते हैं। संविधान में क्या क्या लिखा है? संविधान में तो लिखा है आर्टिकल 351 कि इस देश के सभी नागरिकों को संस्कृत भी आनी चाहिए। कभी मदरसे में अपने संस्कृत पढ़ाएंगे? नहीं पढ़ाएंगे। संविधान कहता है कि आर्टिकल 44 इस देश में समान नागरिक संहिता होनी चाहिए, लेकिन ये कहते हैं मैं तो पर्सनल लॉ चलाऊंगा। संविधान कहता है समान शिक्षा होनी चाहिए, ये कह रहे नहीं मैं मदरसा चलाऊंगा। संविधान कहता है गौहत्या पे प्रतिबंध होना चाहिए, ये कह रहे नहीं मैं तो गाय को खाऊंगा। तो इनके खाने के दांत अलग हैं, दिखाने के दांत अलग है। मेरा बहुत सीधी सी बात है, हमारे पूर्वजों के ऊपर तलवार के दम पे राज किया गया। आज हम स्वतंत्र हैं। अगर स्वतंत्र भारत में हम अपने पूर्वजों का सपना साकार नहीं कर पाएंगे तो हमारे लिए स्वतंत्रता का कोई मतलब नहीं रह गया। किस बात की आजादी कि अगर हम अपने राइट टू कल्चर जो हमारा जो संस्कृति है अगर हम उसको रिस्टोर न कर सके, हम अपने हमारा जो राइट टू रिलीजन है वो हो ही नहीं सकता जब तक हमारा काशी मथुरा जो हमारे प्रमुख मंदिर हैं उनको मैनेज करने का, उनको मेंटेन करने का, उनको ओन करने का, उनको एक्वायर करने का, उनको कंस्ट्रक्ट करने का, उनको रिकंस्ट्रक्ट हमें अधिकार नहीं मिलेगा। तो किस बात की आजादी, किस बात?
बिल्कुल, मेरे पास समय कम है, बट विष्णु जी, आई वांट टू गेट योर रिस्पांस ऑन दीस टू एस्पेक्ट्स विद असदुद्दीन ओवैसी स्पोक अबाउट. He said that when the Kashi Vishwanath corridor was being built, land was exchanged with Muslim parties. So that means there is confirmation of ownership. That's what he said. But he didn't mention that whether it was part of the Gyanvapi Parisar or not. That he didn't say. The other thing, he cited the Deen Mohammed case, saying the judgment there says that this mosque belongs to Muslims. Or this area belongs to Muslims.
I'll reply to both the questions. First, I'll reply to both the questions. First, the question of Deen Mohammed. In Deen Mohammed's case, Hindu society was not a party, so Deen Mohammed case is not applicable to us. In fact, the Hindu society made an application to become a party and it was rejected. And it was not a proceeding like Order 1 Rule 8, which was a proceeding in Ram Mandir case. Nobody is a party in Ram Mandir case, but despite of the fact that it was a proceeding under Order 1 Rule 8, it is binding on everyone. Point number one. Point number two, you asked that there was an exchange. Owaisi said that there was an exchange of this property, therefore the title has been accepted. Now the point is that if exchange of the property of the deity has been done by the government, then that exchange is not binding on us. And in that, I want to make a sub point, and we argued it before the court, that this so-called exchange was in violation of the Waqf Act because no permission and no NOC was taken by the Waqf board. So there the provisions of Waqf Act has also been violated. And apart from that, if government makes some exchange, the concession given by the government is not binding on the devotees. As well as the trustees, as well as the deity.
So that's how you have tried to answer this question. But let me just ask Dushyant Sridhar, prima facie, is there enough for the court, for the Hindu Paksh to go ahead and prove that Ma GyanvapiShringarGauri, access to her is a fundamental right? As per Vedic rights and our Sanatan rights,
Yeah, right. From the verse of Ramayanam, which is regarded as Adi Kavyam and has been even ratified by many historians as one of the earliest works, there is a word called as Aradhaya Jagannatham Ikshvakukula Daivatam. So from this verse of, from this line in Ayodhya Kandam of Valmiki Ramayanam, Aradhaya Jagannatham, Aradhanam, which is worship, was performed in Ayodhya. So there is we have a precedent to worship. Next, coming to Bhagavatam, we have the worship of the idol which was done by Krishna, and later it was given to Guru and Vayu. So there are ample evidences in our Dharma Shastram and in our Anika Shastram and in the Agama Shastram which says that idols have to be worshipped, which the word idol itself is wrong. Idol is a very Western word. The Vigraham, the Murti has to be worshipped and it has to be worshipped in the very same place, and there is precedence even till 1991 or 93 that you have quoted in this particular debate that people were worshipping the deity. So when the worship is happening once a year, it doesn't matter even if it happens 365 days a year. So what can be, it can be extrapolated, right? So it can be done 365 days a year. So there is precedence for this, and Kashi is a very important and a recorded kshetram in all our Puranas. And I honestly feel without any bloodshed, without any kind of hatred by one community to the other, I feel there should be a lot of magnanimity from the other side, telling the devotees that, well, this is the Bhaichara can now come into picture, saying that let me allow my brothers and sisters to come in.
Well, the Hindu Paksh expects magnanimity, but then there are others who believe that if there are those who can continue to use what the Hindu Paksh believes is the place of Adi Vishweshwar, the seat where he resides, and that's being used to play as a place as a Vazukhana, then is there really the magnanimity from both sides? So that's another counter, but it's all a matter that needs to be proven in court. विष्णु जैन जी, घूम फिर के सवाल एक बहुत छोटा सा है कि अगर साल में एक बार मैं पूजा कर सकता हूं तो 365 साल क्यों नहीं? आपको लगता है यहाँ पर आके सारी सुई अटकेगी?
बिल्कुल एब्सोल्युटली राइट आनंद जी. आई थिंक यू हैव गॉट द हार्ट ऑफ द मैटर कि अगर एक बार पूजा हो सकती है तो ये कौन सी डिक्टेटरशिप है कि साल में रोज पूजा नहीं हो सकती? और ये हमारा सिविल राइट है, ये हमारा कॉन्स्टिट्यूशनल राइट है टू डू पूजा ऑफ माँ श्रृंगार गौरी ऑल्सो एज विजिबल एंड इनविजिबल डेटीज विच आर एग्जिस्टिंग इन द प्रॉपर्टी इन क्वेश्चन every year, every day in a year. So therefore we have filed petition with that perspective and that aspect, and I think in future it will find favor with the honorable court and the judgment will be passed, and we are ready for a very long battle even before the High Court and the Supreme Court, but we are not going to compromise even on a single inch of this land.
जी, final word Ashwini ji, yeah, 30 seconds.
देखिए, मीडिया इज द फोर्थ पिलर ऑफ डेमोक्रेसी. विल फाइल ए पिटिशन इन द वाराणसी कोर्ट. विल रिक्वेस्ट द कोर्ट, please allow the electronic media, English, news, Malayalam, Telugu, every media for one day. एक दिन के लिए वहां मीडिया को अलाउ होना चाहिए. मीडिया जाए वहां पे क्या क्या एविडेंस है पूरे देश को दिखाए, क्योंकि जब तक मीडिया वहां एंट्री नहीं होगी एक दिन के लिए, तब तक ये झूठ की जो फैक्ट्रियां घूम रही हैं झूठ घुमाती रहेंगी. मुझे लगता है ओवैसी क्या बोलते हैं उससे ज्यादा इफेक्टिव होगा जब CNN का चैनल जाएगा और वहीं से लाइव दिखाएगा और पूरा इंडिया नहीं बल्कि पूरा दुनिया देखेगा.
देखिए, आप बस वो टेप्स ही पब्लिक करा दीजिए जो सर्वे कमिश्नर, एडवोकेट कमिश्नर ने किए, वहीं से सब कुछ दिख जाएगा. प्रत्यक्ष को प्रमाण क्या. इफ यू मेक दैट पब्लिक एवरीबडी विल नो. आई हैव टू एंड ऑन दैट नोट. शिवम शिवकरम शांतम शिवात्मानम शिवोत्तमम. So thank you very, very much. Let's see. You have to prove your case. You've got a hard task ahead. So far, it's the first step. Thank you very, very much. We're going to take a very, very short break, ladies and gentlemen. Stay with us. Ram Madhav on the GyanvapiShringarGauri when we come back.